Hello, and welcome to Know Your Rights, a short video series from Nevada Legal Services. Today, I'm going to talk about how to appeal the denial of a claim for unemployment benefits in Nevada. My name is Ray Gertkin, and I am an attorney with the Reno office of Nevada Legal Services. Nevada Revised Statutes Chapter 612 covers unemployment benefit eligibility, payment of benefits, and appeals of unemployment benefit ineligibility. This video will explore how to appeal a decision denying benefits. We will start with a brief overview of the claims process. When you file the initial claim, you need to give the reason why you are no longer employed. Be careful. If you quit your employment or were fired for cause, do not put that you were laid off. Your employer will have the opportunity to respond and submit evidence challenging your claim. After you apply, a claims adjudicator will interview you over the phone to get further detail about your claim. Again, be truthful. If at any point the Employment Security Division believes you have made a misrepresentation in order to get or increase your benefits, your claim will be denied. You will have to pay back any benefits you've received and possibly be disqualified from receiving benefits for a year. Finally, after this interview, the initial claim determination will be made. Either party may appeal the initial decision within 11 days. Your appeal must be in writing, include your Social Security number, and be signed. Finally, through the entire appeal process, you must continue filing weekly claims or you will not get full payment of your benefits if you win at any stage of the appeal. Once you appeal, the next step is a hearing before an appeals referee. This hearing is the only avenue to submit evidence before a hearing officer. You can subpoena witnesses for the hearing, introduce documents, and provide testimony under oath. Make sure to get any documentary evidence into the hearing office before the hearing. You will also be provided with a hearing packet, likely uploaded to your online account to review the file and evidence submitted before the hearing. Hearsay is admissible, and the rules of evidence that would apply in a court do not necessarily apply in an administrative proceeding. You still have the ability to object to any evidence or witnesses, to raise any concerns or explain why that evidence is untrustworthy. The hearing officer will then issue a written decision after the hearing. If you receive an unfavorable decision after the initial hearing, you can appeal the appeals referee's decision to the Board of Review. Again, this appeal must be filed 11 days from the date of the decision of the referee. This appeal must also be in writing, signed, and include your Social Security number. You should also include your reasons behind the appeal. The Board of Review is not required to hear every appeal. The only time the Board of Review is required to hear an appeal is if the appeal referee came to a different decision than the original adjudicator. If you do not prevail before the Board of Review, the next step would be to petition the District Court for judicial review of the decision. This petition for judicial review must be filed 22 days from the date of the decision of the Board of Review. NRS 612 governs appeals of unemployment decisions, but NRS Chapter 233B, the Administrative Procedure Act, applies where Chapter 612 is silent. Again, the initial hearing is the only true evidentiary hearing, and you generally cannot submit new evidence in the District Court. It is extremely important that you get all evidence and address all issues in the hearing before the appeals referee. If you lose in the district court, you can appeal to the Supreme Court, but the rest of this presentation will focus on what is required to appeal in the district court. Your petition must be filed timely, and the county where you were employed must name all the participants in the hearings before the agency, including the agency, and you must serve the Employment Security Division or ESD administrator within 45 days of filing the petition. You do not need to serve all of the parties. You only need to provide ESD with 4 copies of the petition, and the ESD administrator then serves the remaining parties, including the employer. Failure to abide by any of these requirements could result in the dismissal of your case. You do not have to post a bond to file the petition for judicial review or pay a filing fee, although some courts will require you to either pay a fee or file a fee waiver. This is not necessary pursuant to NRS 612-705. No matter what, your petition must be filed timely. If it is not filed on the day it is due, your petition will be dismissed. Generally, a court will not substitute its judgment for that of the agency. Therefore, you must argue that the decision was a clear violation of law, or that the agency's decision was not based upon substantial evidence, was arbitrary and capricious, or was an abuse of discretion. Our sample petition for judicial review lays out these grounds as the basis for the appeal. Your job is to lay out legal arguments in your opening brief that provide the court with the legal basis to overturn the agency's decision. You can find sample pleadings on our website at nlslaw.net, Know Your Rights, Work and Employment. Once you file the petition and serve ESD, ESD must submit the record on appeal pursuant to NRS Chapter 612. This means that ESD will provide a transcript of the hearing as well as all other evidence submitted in the previous hearings to the court. You will then have 40 days to submit an opening brief laying out your legal arguments to support your petition. Some of these legal arguments are included in the sample opening brief on our website. Thank you for watching this presentation in the Know Your Rights series on the Nevada Legal Services Now YouTube channel. Please contact any of our local offices to see if you qualify for further assistance if you have been denied benefits. You can also access more information on our website at nlslaw.net.